regulations, more reporting requirements, the situation has not improved. And basically, the reason is that unless the professionals regulate themselves, their own conduct, no external regulator can improve the things to the extent it is desirable. And given the ecosystem in which we are operating, the level of governance is very poor, and that leads, or rather that motivates people to do more non-compliances, because the premium for non-compliance is more than that for the compliances. So one thing which is required is the improvement in our ecosystem in terms of better governance, better accountability, and better transparency. That has been the object of the regulators over a period of time. I'll just share the PPT. Please confirm that you are able to see the PPT.
Yes, sir.
Any initial observation from the participants about what they feel regarding compliances as of now? Frank opinion. No one wants to share? Most of you have put off the videos so that I can't see. But those who have put on the video, at least if they would like to share their thoughts on the issue of compliances. Gupta ji?
Sir, I feel compliances are too much, and there is no interlink between NCLT, IBBI, and IPA. So we have to do filing separately at every place.
It's true. Of course, they are trying to interlink in the sense that about a month or so back, they asked for the case number to be linked to your IP portal so that they can see the details from the NCLT website. On the background, a lot of work is going on for IT connectivity with these regulators and the adjudicating authority. As far as the IPA is concerned, some of the jobs like updating the CP hours, the AFA, all these are on the IBBI portal, and these are being accessed by the Insolvency Professional Agency. So work is going on, but yes, you are right that still a lot of things are required to be done to reduce the multiplicity or duplication in the reporting to the different agencies. Anyone else? Mrs. Vyas? You please unmute yourself.
Too many compliances. I mean, when we are not aware, suddenly we are aware that we have been appointed as an IP, maybe in the case of Section 9. So when the assignment starts, so many compliances, we have to do it simultaneously to the NCLT, IBBI, as well as IPA. So that one is to be, I mean, after doing so many things, then IP, I mean, if nothing is done, then IP is responsible for everything, like that.
Yes, yes, yes. That's the challenge of this profession, as well as that is the attraction of this profession.
Yes, sir.
Because you have to do simultaneously so many things within a very limited time span available to you. Now it's just like an automated machine. The moment there's an order, you have to do this,
Correct.
and you have to be well prepared. You have to be prepared in advance to get in the compliance done properly. Mr. Sohas,
Sir,
you are smiling on others' comment.
Sir, I actually also observed that the compliance part is
is very difficult in particularly IP cases. If at every stage, whether you are IP or you can be appointed as a liquidator, the compliance part is a bit difficult and cumbersome in the sense you'll have to do lots of job. I mean, in one case, you'll have to comply about the other parts of the IP, and on other side there is a compliance. Like I believe that we are rather appointed as a compliance officer than IP, because in many cases the earnings and everything are very less as compared to what are the compliance we are doing. So I don't find sometime it is fruitful job, like that. We only does compliances. That's the only point.
Yes, in terms of sustainability of the profession, there are questions. Like we always talk about that the cost of the CRP should be less, the CD should be sustainable, but nobody appreciates that whether the professional should also be sustainable. The professional is here to make earn a fee. It's not for charity. So
Agree.
the profession should be sustainable in terms of the remunerations or the reward and the work done. Of course, the code of conduct specifies that the remuneration should be as per the assignment. So that's you are not to charge very high fees. Similarly, you shouldn't be forced to accept very low amount of fee so that you are not sustainable over a period of time. And another thing is that when things are not so transparent and the fee is not sufficient, people indulge in other kinds of activities which is not desirable. Of course, the IBBI had come out with the modifications prescribing a minimum fee, but that has also not helped in the sense a lot of people are complaining that now that has become the benchmark. And the COC is not approving a fee higher than that, even if it is justified by the size and scale and complexities of the operations of the corporate debtor. So that happens when we try to improve something with a particular object in mind. It is not necessary that happens. There may be a different dimension by different stakeholders. So that's really a challenge. Of course, we can categorize that there are cases where the remuneration is very good, large ticket cases where the big four or the IPs are taking up the assignments. In the medium-sized corporate debtors, it is reasonable, but in large number of the cases, the remuneration is not sufficient or it is not paid in time even. Particularly in the real estate cases, the situation is very, very difficult. People have not got the remuneration for 3 to 4 years and the resolution plan is not approved. It is either pending at the level of NCLT or it is prone to litigations at different stages.
Absolutely.
So that's the challenge. Anyone else to share the opinion before we start with the PPT driven session? Mr. AKV, would you like to? Okay, so it means no one would like to share. So we go ahead with the PPT. When we talk about IBC, there is a talk that there are 4 pillars of IBC. And IP is one of the most important pillar as far as the functioning is concerned. That is why IP is narrated as the fulcrum of the IBC processes. And there are other 3 pillars, that is the adjudicating authority, regulator, and information utility. So out of that, the most onerous responsibilities with the least rights or least amount of compensatory remuneration is the insolvency professional. because the regulator is a government body, the adjudicating authority is a government body. Information utility is also a sort of corporate floated by the government institutions. So the most affected pillar, having the highest burden, is the insolvency professional. So when we enter this profession, we know it very well, and we should prepare ourselves for the challenges which an IP will face, so that the compliance is not compromised, the transparency is not compromised, and the overall object of IBC is not compromised. So knowing well that these are the challenges, we should enter the profession. And accordingly, also we should negotiate and get the fees fixed before entering into it. This slide describes the position of IP. As compared to this gives the realistic situation of how the IP is locked between the regulator, the adjudicating authority, and the various stakeholders. And it's a very challenging and demanding task which is required of the insolvency professional. Now, as far as the compliances are concerned, we will discuss it with reference to the BLRC report, the code, the rules, regulations, the circulars and guidelines and judicial pronouncements over a period of time as to how it has evolved. Now, the first thing, we take up the BLRC report. Okay. And these are the various regulations under which the obligations is cast on the insolvency professional directly or indirectly. Like these regulations related to grievance, complaint, IP, inspection and investigation, IPA and model laws of the governing board are directly affecting the compliances of the insolvency professional. Apart from that, specific regulations with reference to a process under IBC also defines a lot of responsibilities or the reporting requirement. So we will try to take an overview of all these regulations briefly in terms of what are the compliances or the regulatory requirements with reference to submission of report or filing of details with IBBI or the concerned insolvency professional agency. And over a period of time, the situation has become like this: modifications. It is becoming more and more complex in terms of compliances and in terms of understanding the regulations and the play between different regulations. Because if you see over a period of time, there are some regulations added into CRP regulations, which deals with the situation of liquidation. Similarly, there are some changes done in the liquidation regulations, which takes care of the work done under the CRP process, like the claims or the valuations. So now these are not isolated or separate sort of regulations for a specific process. Now there is interlinkages between various provisions or the regulations for the different processes under IBC. And this is the most important part, what is expected of an insolvency professional. We are in a situation like that. The ecosystem governance level is poor. The things are not perfectly managed, but an insolvency professional has to be like the lotus, always floating on the mud and not getting influenced or affected by it. And this drops indicate that the whole process has to be in a very transparent manner. So you can compare the two situations. This is what the ecosystem in which we are operating, and this is how the IP should look like. That's the expectation of the regulators as well as all the stakeholders. Now, first we discuss the relevant provisions or the relevant paragraphs from the Bankruptcy Law Reform Committee report, which was the basis of IBC. This indicates what we have already discussed. Like this situation was apprehended. The complex nature of the present day business world and the complexity of the laws and regulations are in their very nature capable of giving rise to great temptations, which may in turn persuade the professional manager to deviate from the path of right conduct. Here the problem starts. When the professional tries to deviate from the path of right conduct, all these issues related to governance, compliances, monitoring becomes more and more stringent. There are indeed too many snares and traps which might lure to deviate from the right path. Professional has to exercise great restraint in not falling a victim of these lures. Because once you feel you are the boss, you are replacing the board, you are assuming the powers of the board of directors, you feel you can do anything what you would like to do. So this kind of situations are like lures which tempts the insolvency professionals to do things which they are not required or supposed to do. The role of the IPs is thus vital to the efficient operation of the insolvency and bankruptcy resolution process. A well-functioning system of resolution driven by IPs enables the adjudicator to delegate more and more powers and duties to the professionals. The worse the performance of IPs, the more the adjudicator may need to personally supervise the process, which in turn may cause inordinate delays. That's what is happening. Here it is not the adjudicator, it is the regulator which is concerned about the performance of the insolvency professionals and thereby enacting more and more stringent regulations requiring more and more reports to be either uploaded on the IBBI portal or to be filed with IBBI or IPA. So the object is to keep the professionals on the right path and to have a fear in terms of like if you deviate, you will face the consequences. So this is all perceived. It was visualized when this law was being framed. And that's what exactly happening now. Instead of the adjudicator, the regulator is making more and more close supervision. Consumers in a well-functioning market of IPs are likely to have greater trust in the overall insolvency resolution system. On the other hand, poor quality services and recurring instances of malpractices and erode consumer trust. What happens when one of the insolvency professionals indulge in an activity which is not warranted? The whole profession is exposed to the media, negative reports, and it somehow created an impression in the minds of other stakeholders and the public at large that the IPs are not performing efficiently or that they are not doing the things in a very transparent manner or honest way. And that has hampered or affected the image of this profession very fast. See, all other professions are very old as compared to the IP, but within a span of 6 to 7 years, it has traveled from a very hyped position to a very negative perception about that in the minds of various stakeholders, all because of the actions of a few insolvency professionals. As we discussed in the beginning, the profession is over-regulated. So I'm just sharing a few instances in the very beginning, which had led the regulators and the adjudicating authorities to become more and more stringent, to add more and more regulations, to add more and more reporting requirements. This is one of the oldest cases by NCLT. You must be aware of it. It's part of the curriculum for LIE and PREC. The total outstanding debt of the corporate debtor was rupees 4.16 crore, including interest and retention money. The annual remuneration of the MD and CEO and the two whole-time directors of the corporate debtor was rupees 1.1 crore. But the IRP who was proposed, it was an application filed by an operational creditor. The proposed fee was rupees 14 crores. And that forced the NCLT Hyderabad to pass strictures against the insolvency professional and directing the IBBI to look into it and initiate disciplinary process. So these are the types of glaring examples which virtually forces the regulator or the monitoring agencies to be more and more stringent. It was not without any reason. The second instance is that RP collated the claims of a financial creditor and held that claim amount as nil. On an application filed before the NCLT Chennai, and after considering the records, NCLT accepted the total claim. So just see the deviation or the kind of approach of the insolvency professional. When the adjudicating authority found that the total amount was due, the RP has rejected it and took it at nil. And he didn't stop at that. He challenged even the decision of NCLT and went in appeal before the NCLT. NCLT dismissed, saying that the RP is to abide by the directions of the NCLT. The RP should not challenge the decision, particularly as regards the claim, because if the adjudicating has found that the claim is in order, he should go with it. What is his interest to put a challenge before the appellate authority? In another case, CBI arrested IRP and his associate for receiving a bribe of 3.5 lakh from a consultant by threatening him with a criminal case. So these are some of the examples where the adjudicating authority identified misconduct on behalf of the insolvency professional and directed the IBBI to look into the matter and take appropriate action. There are some more, we'll just discuss few more examples, the oldest ones also, which was observed by the regulatory authority. IRP did neither include the claim in the list of operational creditors nor respond to the claimant for a claim of rupees 72 lakh. He even didn't respond to IBBI queries till notice for disciplinary action was issued. So thereafter, he filed an application before the adjudicating authority seeking guidance on admission of disputed claims, and thereafter admitted the claim, because the adjudicating authority also reprimanded, saying that the adjudicating authority is not an advisor or a consultant to the IP. It is to adjudicate the matters, and the IP should take a decision based on the facts available and the documents available. Another interesting case which led to the first disciplinary action by the IBBI way back in 2017. Here, the RP modified the EOI approved by the COC with the approval of only one financial creditor. See, the provision related to EOI is that RP will propose the criteria and it will be approved by the the committee of creditors. So here, he even modified the criteria which was approved by the committee of creditor just at the instance of one financial creditor. Another thing he did was that he outsourced verification criteria to a chartered accountant appointed by the interested party. Like he said, the prospective resolution applicant will appoint a chartered accountant who will certify that the contents of the EUI are in order and they are eligible as per the criteria fixed by the COC. Had it been a CA appointed by the RP, reporting to him and RP being responsible for his conduct, would have been a different issue altogether. But here, the RP asked a third party to appoint a CA, and he decided to go blindly with whatever certification the CA has given. RP also didn't appoint a forensic auditor, but used the services of a forensic auditor who was earlier appointed by one of the financial creditor in the same account. So that was not keeping in independence. Like he was affected or influenced by the dominant financial creditor, which was not as per the scheme of the code, or which was not as per the desirability of independence of the insolvency professional. So these are a few examples. I've just given these examples to indicate that the process of increasing compliance burden is because of our own fellow professionals who have gone out of the way, who have not followed the right path. And because of that, the whole community of the insolvency professional is facing more and more reporting and monitoring requirements. Like these are the different roles an insolvency professional can play as per the code. Like he can be an IRP, RP, liquidator, bankruptcy trustee. He can be the financial, or he can represent any member of the committee of creditors. He can also be authorized representative. Now, in terms of the reporting requirements, the worries of the regulator is because of the huge amount of responsibility put in, or the powers of the insolvency professional. That's why they are more worried. We'll not discuss the entire range of the responsibilities of the RP or the insolvency professional. You just see the three major requirements, which indicates the kind of position or the kind of responsibility which the insolvency professional has. See, first is that he is responsible for complying with requirements under any law for the time being in force on behalf of the corporate debtor. So it's a very, very onerous responsibility on the insolvency professional. The second one is to protect and preserve the value of the property of the corporate debtor. Third one is continued business operations. This may look like a very, very onerous responsibility, because when there is a stress in the company where the continuing operations are difficult to maintain, the RP is obliged to maintain the continuity of business operations. So all these are the major responsibilities which distinguishes the profession of IPs from all other professions. It makes it unique, more responsible, more onerous, and more powers. Apart from that, Section 28 requires that major financial decisions relating to the corporate debtor are being taken by the consent or prior consent of the committee of creditors. So in terms of the various types of roles which an IP can play, in terms of the major responsibilities of an IP, which distinguishes it from all other professions, we come to the responsibilities of reporting or following the code of conduct as per the code. So this is the source of all the powers given to the regulator in terms of monitoring or regulating the profession of IPs. That flows from Section 208, subsection 2 of the Insolvency and Bankruptcy Code, which prescribes that the insolvency professional shall abide by the following code of conduct. Here only 5 items are mentioned, but based on that, a detailed code of conduct has been prepared for the insolvency professionals, which has very wide-ranging clauses in terms of the responsibility. So the first responsibility which flows from Section 208 is that the IP has to take reasonable care and diligence while performing his duties. So it's a very broad structured provision which encompasses the duties of the insolvency professional. The second one is to comply with all requirement and terms and conditions specified in the bylaws of IPA. So by virtue of this clause, even the regulations or bylaws of the IPA also binding on the insolvency professional. The third one says to allow the IPA to inspect his records. So here, powers are given to the insolvency professional agencies to inspect the office or records of the insolvency professional at any point of time. Now, this is the most important provision which deals with the compliances, which gives to submit a copy of the records of every proceeding before the adjudicating authority to the board as well as the insolvency professional agency of which is a member. So this is the source for all those reporting requirement in terms of the various proceedings or litigation before the adjudicating authority. And because of this, the practice of periodically submitting a status report to the adjudicating authority as well as IBBI has been initiated. To perform his functions in such manner and subject to such conditions as may be specified. So here it gives powers to the IBBI to prescribe or specify what kind of responsibilities or reporting requirement will be there for insolvency professionals. So this is the enabling provision under the code. Now we see the provisions under IP regulations. So here this is the regulation related to the registration, and it requires that the whatever conditions of registration are there, the IP will follow it all the times. And this requirement for continuing professional education was added at a later date. Clause BB was added not to outsource any of his duties. So the genesis or the origin of this provision was one of the case which we have discussed, where the IP asked the third party prospective resolution applicant to appoint a chartered accountant who will certify that the EOI is in order. So if you see the evolution over a period of time, because they found some lacuna or some actions on the behalf of IPs which were not desirable, they kept on adding more and more stringent regulations requiring either the reporting, monitoring, or performance of the insolvency professional. This is regarding the fee, and then a percentage of the fee is to be paid to the IBBI every year based on whatever you earn. Another requirement is in terms of a percentage of the CIRP cost to be paid. This was added last year, that a fee specified under Regulation 31A of the CRP has to be paid within 30 days. So this is also in terms of the compliances and requirement. Not only the reports, you will have to pay a certain amount of fees, certain amount of your fee share plus the certain amount of the expenses which you incur or on the value of the resolution plan. A regulatory fee calculated at 0.25% of the realizable value to the creditors under the resolution plan approved under Section 31 shall be payable to the board where such realization value is more than the liquidation value. So this is in terms of keeping the IBBI self-sustainable, reduce its budgetary support from the government of India. But this has added to a compliance burden on the part of insolvency professionals. Again, on whatever cost the insolvency professional incurs during the CRP period, 1% is to be paid to IBBI. So that is also the responsibility of IP. This we can skip. Okay. Any queries on the issues which we have discussed so far before we go to the next section? Okay. Now we come to the disclosures required to be done by the insolvency professionals. What is the first disclosure which an insolvency professional has to make? When an IP is appointed, what disclosure he is required to make? Anyone from the group?
Eligibility as well as independence.
Yes. How that is declared?
Through a written submission to the adjudicating authority.
Okay. In what form?
By way of IA.
No. Before your
And also-
appointment, when you give a consent,
Sir, IP1 is to be filed.
that
Form
is
2.
Form 2. The beginning of your assignment journey is Form 2. And Form 2, there are certain disclosures regarding your independence. Like whether you are capable of being appointed as an independent
Right.
director in the corporate debtor or not. So this is the first disclosure which starts even before getting an assignment. This is at the time of your appointment, and that is in terms of Regulation 3 of the IBBI CRP regulations. And what is that? It requires a disclosure at the time of appointment and thereafter in accordance with the code of conduct. Apart from that, this declaration has to be added in Form 2. The Form 2 doesn't contain this declaration, but the adjudicating authority will ask for it. Unless this is there in the Form 2, they will not accept your appointment or they will not clear your appointment. This has to be added. So initially what has happened that people started appointing the related parties or relatives or close acquaintances in the various positions which the IP was authorized to appoint. So in January 2018, IBBI came out with a circular for disclosure of relationship. So there is a difference in the disclosure of relationship under this and the disclosure at the time of appointment. This is a restrictive one. Like it says, if you don't qualify these criteria, you will not be eligible. You can't be appointed if you don't fulfill the criteria given in Regulation 3. But here, the new circular that was only for making it transparent. There is no restriction. But if a certain situation happens, then you have to declare that relationship. And they have made it on the portal of the Insolvency Professional Agency where you can declare this type of relationship. Later on, it was made part of the Code of Conduct and in the form of clauses 8B, C, and D. So this is the relationship which has to be disclosed. Somebody would like to read this slide?
Yes, sir, I can.
Yes, please.
Sir, relationship of the IP with the corporate debtor. Disclosure is to be made within 3 days, I guess, of his
Yes.
appointment.
Yes.
Other professionals appointed by him, that is valuers, accountants, legals, and others. Appointment of the disclosure is to be made that the appointment of the professional has been made within 3 days only. Financial creditors, that is after the constitution of COC. If any interim finance is provided, then that is to be reflected through the relationship disclosure, the agreement with the interim finance provider. Prospective resolution applicants, the supply of IM to the prospective resolution applicant. If relationship with any of the above comes to the notice or arises subsequently, of such notice after the, whenever it has come, you have to report it accordingly.
Yeah, thank you for reading it out. So this is the set of relationship the IRP or RP has with any of these stakeholders, like the corporate debtors or the professionals appointed by him, financial creditors, interim finance providers, prospective resolution applicant, and that relationship disclosure has to be within 3 days of happening of that. Either way, like appointment or appointment of the professional, the constitution of COC, the agreement with the interim finance providers, and supply of IM. So very brief or short timeline is put in for disclosure. Now, what happens in case the constitution of COC is by the operational creditors? Does it apply? The relationship disclosure has to be made or not? Because here it says with the financial creditors when the COC is constituted. But if in the eventuality, when the COC is constituted of OCs, then what happens? What is the situation when the COC is constituted by the operational creditors? Anyone?
Then also, I
Yeah.
think reporting is to be done.
Yes. Though here it is mentioned as financial creditors, but going by the intent of this circular, when the constitution of COC takes place, and if it is by the operational creditors, so then also the IP should disclose relationship, if any, with the members of the COC. Now the next slide is similar to the first slide. The only difference is here the relationship of other professionals with these stakeholders is defined. And similarly, again, it is the timeline of 3 days within which the relationship has to be disclosed. So here, the RP, when he is appointing any of the professional, one of the part of the appointment conditions will be that he will declare the relationship. And how will he declare the relationship? Unless the IRP or the RP provides the details of these. Corporate debtor, of course, he will know. But then he has to also provide the details of financial creditors or the members of the COC to the appointee and seek a declaration that is he in any way related to them. So that becomes a, again, onerous responsibility to be completed within a short period of time. Now, the next part is more important. Here it describes the relationships. So the relationship has been categorized into 4 types. Again, I'm making it very clear. Even if somebody falls into these 4 parameters of relationship, there is no restriction. It is only to be declared, just to make it very, very transparent. And it has to be declared on the portal of Insolvency Professional Agency. So may I request someone else to read this slide, narrating what are the kinds of relationship which is being considered here for declaration. Anyone else volunteering to read it? May I request someone, Mr. Manish?
Pardon, sir?
Can you read this slide?
Yeah, definitely, sir.
Yeah, please.
Yeah, a relationship type, nature of relationship, where the IP or the other professional, as the case may be, has delivered 5% or more of his or its gross revenue in a year from the professional services to the related party. Next is point number B, where the IP or the other professional, as the case may be, is a shareholder, director, or the key managerial personnel, or the partner of the related party. Point number C, where a relative, spouse, parents of spouse, sibling of self and spouse and children of the IP or the other professional, as the case may be, has a relationship of kind A or the kind B with the related party. Point number D, where the IP or the other professional, as the case may be, is a partner or director of a company, firm, or the LLP, such as an insolvency professional entity or the registered valuer. The relationship of kind A, B, or C of every partner or director of such company, firm, or LLP with the related party.
Thank you for reading this slide.
Yeah,
Does
thank
it
you, sir.
make it clear or confuses?
Clear, sir.
Very elaborate description of a relationship. So here what you have to do is that you only have to declare. There is no restriction. When you are declaring at the site of IPA, you'll have to say that what is the relationship, A, B, C, D, or none. There's no restriction. So one has to do it very carefully and see whether the relationship of any type described here gets attracted when you are making any appointment or not. Similar disclosure has to be done under the liquidation process. The liquidator shall disclose the existence of any pecuniary or personal relationship with the concerned corporate debtor or any of its stakeholders as soon as that becomes aware of it to the board and the adjudicating authority. Now here the question is, as far as the CRP is concerned, a very elaborate details of relationship was given. In that circular, it has been described So what will you do in terms of the relationship disclosure as far as the liquidation process is concerned? Where the relationship is described. No one? Yes, Ms. Subham. Where is the relationship described under the code? How would you comply with this requirement? If you are a liquidator, you are required to disclose the existence of any pecuniary or personal relationship with the concerned corporate debtor. So how would you identify that whether relationships exist or not? Anyone else?
I can read, sir.
Yes, please. No, you don't have to read. What I'm saying is, like in case of the corporate insolvency process, very detailed circular was issued and which was later on made part of the code of conduct. What
Okay.
about the relationship disclosure under the liquidation process?
Okay.
How would you define? How do you identify that you are related or not? What will be your guidance? No one in the group of 66 participants? So the answer is very simple. This one is, earlier it was by way of circular, now it is part of the code of conduct. So code of conduct is applicable in all situations, whether you are acting as the IRP, RP, liquidator, bankruptcy trustee, or anyone. So this is the guideline which is applicable even in case of liquidation. Second thing is, where is the relationship described in the code? Section 524 and 524A. Section 524 talks about the relationship with the corporate debtor. And 524A is for relationship with the individuals. So one has to look into those provisions, and accordingly, if any of the relationship is there as identified under those two subsections, then it has to be reported. Is that clear? Now we come to the detailed reporting mandate. This was the first circular which initiated reporting by the insolvency professionals. That was 12th June 2018. That means before that, there was no additional requirements in terms of filing reports otherwise than given in the code. Now this has been made part of this form CRP2 and CRP5. Earlier, these three forms were required to be filed. One when the IRP was demitting office, and second when the RP was demitting office. So now these details have been incorporated in form CRP2 and CRP5. We will discuss that when we come to these two forms. It is just for your information that when this additional requirements has started flowing in, this was for disclosure of fee and other expenses incurred by the insolvency professional, interim, or the regular RP. After that, IBBI introduced 5 CRP forms. with effect from 14th August. That is almost a year after initial these forms were prescribed. Then they came out with 5 forms, and earlier it was by way of circular. Later on, this was incorporated in the CRP regulations. So a new regulation 40B was added, which takes care of all the forms to be filed by you. And which are these forms? These were the 6 forms initially. First is IP1 pre-assignment within 3 days. So this pre-assignment form is applicable for
Section 7.
आम्ही वरतून बघायला लागेल ना, इथून नाही बघताय, वरतून जाऊन बघायला लागेल.
Yeah, may I request others to mute the mic? So when this pre-assignment form is to be filled in?
Under section 7 application, when we are giving our consent. So when we are giving our consent in form 2, at that time, within 3 days, we have to file this one IP1 form.
Okay, good. And what if the consent is given under section 9?
Then also.
So whether under section 7, 9 or 10?
10.
Within 3 days of giving consent, this form has to be filed in. And what about liquidation?
So liquidation also, the form is to be filed even under a voluntary liquidation under section 59. The same provision will be applicable, because here the point is pre-assignment. Now any kind of assignment as IP, whether as a IRP or RP or liquidator or voluntary liquidator, this provision will be applicable. That's my submission.
Yes, yes. That's the, see, why did I ask you the question is, this is part of the CRP regulation. It is part of regulation 40B. But this IP1 form pre-assignment is applicable to all your assignments as a IRP, RP or a liquidator. That has to be filed within 3 days of your giving consent. The next form is CRP1. And this now these forms are made stage-wise progress of the CRP assignment. So it is from the commencement of the CRP process. And when does the CRP process starts? From the insolvency commencement date till the issue of public announcement. So all these details during this process period are captured in CRP form 1, and this is to be filed within 7 days of the public announcement. The next one is CRP 2. It will start from the public announcement till replacement of the IRP. So again, within 7 days of replacement of IRP is the timeline. So third stage is from the appointment of RP till issue of the information memorandum to the members of the COC. Again, the timeline is 7 days. Fourth form is from the issue of IM till the issue of request for resolution plan. And fifth form is from issue of RFRP till completion of the CRP period. So these are made stage-wise. During the any of the stage, whatever details are required, the forms are very detailed ones. All
I have one query, sir.
Pardon? Yes, yes.
I have one query. In case of the, as per the law, from the 40th day, the RP should be appointed from the commencement of CIRP.
Correct.
Yeah, but in many cases, the RP was appointed after 60 days or 50 days or maybe after 3 months also.
Correct.
Yeah, so in that case, whether IRP need to submit any form, because either to the IBBI or to the NCLT or IPA, because he is continuing as a RP, deemed RP, as per the provision.
Yes, yes.
So that I have seen that some in some of the cases the RPs are submitting the form to the IBBI, and in that case their name is showing as a IRP also and as a RP also. But I have not submitted any such types of form. So is it necessary or means what as per the law? Kindly enlighten, sir.
You see, the enabling provision, that problem was happening because either the COC was not taking a decision to appoint RP. So what will happen? The regulation was amended and I said, if it doesn't happen till 45th day, it is 45 days, no? Then the IRP will function as RP.
Yes.
All his responsibilities, all the responsibilities of an RP, he has to comply with. So it will be better to file a form. Say non-compliance, compliance is better than non-compliance because you are in the shoes of RP. Though you have not been formally appointed as RP, but you are functioning as an RP.
So which authority we have to submit the form? And
these forms are on the IBBI website.
No, sir, IBBI website, but which form, sir? Because I have not found, sir.
See, these are stage-wise forms. The
Yeah.
moment the stage is completed, within
Yes.
7 days of that stage, you are required to file the form. Like let's see CRP2.
No, data I know,
Public
sir, but
announcement
like CRP3, because this form is mainly for the replacement.
Yes,
So
yes.
until and unless I have not been replaced by the other RP, I am unable to submit the CRP4 or CRP5 form if those stages are also completed. So because I have not been replaced, then what to do, sir? You got my point. Because until
Yes,
unless
yes.
we will not file the CRP3, we will not able to file the CRP4 or 5.
That's what I'm saying, that by this enabling provision, you will have to continue functioning as an RP. You will prepare information memorandum.
Yeah, definitely.
You will share it with the COC members after obtaining the declaration, confidentiality declaration. So you are completing that process. The only thing which is missing is that you have not been regularized as an RP by the COC. But
Yes.
effectively, you are functioning as a RP.
Yes.
So you, in my opinion, you will continue filing these forms. There is another form which we will discuss, that is regarding delay. That is Form 7.
No,
If a thing
yes.
has not happened, then you will report that by way of Form 7. But this is process related. The process you are completing. So you will file the details about the process. Anybody else has...
Sir, now it is incorporated in the code itself, regulation itself, that RP would be deemed to be continue. Sorry, IRP would be deemed to be continue till the replacement of RP. That is now incorporated in the code itself.
Yes,
so CIRP 2 is required to be filed till the replacement of the IRP.
So the essence is that the forms will continue to be filed as per the process progress, irrespective of the fact whether the IRP has been confirmed as RP or not. Isn't that?
Yes, sir, correct. That is the correct position.
Means we need to file the CRP2 form.
Yes, yes.
As soon as the 40 dates are completed.
Yes, CRP2.
Even though we have not been replaced by other.
So it is deemed to be replaced. It is considered as a deemed to be replaced. So you have to fill up that CRP2 form.
Okay, so it's you can say it's per the law. It's
yes.
Necessary to
Yes.
file the
It is
CRP2 form.
It is deemed replacement.
Because you see, in that Form 2, there will be details about the process also. What has been done from the date of public announcement till it is regarding the claims and all other things, constitution of the COC. So all those details will have to be filled in the Form 2. And that's why you will have to file that form.
then sir, when the final order of the NCLT will be there after 80 days, 90 days, or whatever the timeline, then we need not to file any form, because as per the
Then you see, because the delay, you will be filing Form 7.
yeah, that's a separate, but like
Yeah.
replacement.
Yes,
for the
yes.
purpose
After replacement, you need not file any form, because I am following the same thing. I have received email from the IBBI that why you have not filed this form in between. So I said that now RP is replaced already, so I need not form. So they have not again issued me any email. So up to
Okay.
that stage only I have filed form number 7 also. Thereafter I stop it because RC was replaced by NCLT.
Okay, because in my case, what happened that I have not filed the CRP2 form even after 40 days. I have filed only when the final order of the NCLT was received.
And did you get a penalty?
Pardon, sir?
Were you asked to pay penalty for that?
No, sir. No intimation from the IBBA also in this regard. Because I am continuously filing the intimating to the IBBA by other
But
forms.
they will intimate you at any time, not necessary that you will not get intimation. You have to fill up till your replacement is there by adjudicating authority. So you have to fill up form number 7 till the final order comes.
Yeah, definitely. Till the final order of the NCLT is there, I am filing the same. I already filed, yes, form number 7.
And
Sir,
similarly, yes, please.
sir, can I ask a question? In a case where COC has very specifically said that we do not want IRP, we want RP, and they have gone to adjudicating authority, which has taken, let's say, more than a year to approve appointment of that RP. Would it be right for IRP to continue assuming RP's role? Because when there is a very specific resolution passed by COC that they don't want this guy to continue, and hence, but unfortunately, AA has not approved. AA has taken sufficient more than required time, I would say, or more than normal time.
See, the provision was made or deemed appointment of IRP as RP only because there cannot be a vacuum after the insolvency commencement date. Earlier, the provision was that the term of IRP is 30 days. And then it was a legal issue that if there is a delay beyond 30 days, what happens? So the adjudicating authority has held that till the RP is appointed, though 30 days time is given, but till the RP is appointed, the IRP will continue to function. And thereafter, this was amended. Even that code was amended saying that the IRP will continue till the RP is appointed. So despite the COC's insistence, the IRP will continue to perform the activities as per the code and the regulations, and he will also be entitled to remuneration because the finality is attained only when the adjudicating authority approves that appointment. From the date of approval of the adjudicating authority only, he will demit the office.
I will add one more. This is a real life situation, and although I'm not specifying any names here. Now, in this case, specific case, IRP's fees even were not approved from the day one. Okay, nor the expenses are paid by COC. And this COC is not financial institution. These are home buyers, where this typically who will raise the fund kind of situation arises very commonly. Now, how long IRP, just because he's duty bound or law bound to deliver, can function without earning fees and incur expenses?
See, that is the risk and challenge of this profession. Even when you are giving your acceptance for the empanelment, there is a condition that you will not refuse any assignment here. And there is no provision that you can be absolved of your responsibility unless the incumbent or successor RP comes and joins. So that's the risk you will have to continue.
I would say it's more of an onerous, I mean, where, and in this specifically case, IRP also has filed an IA for payment of their fees and expenses, which is also not decided for over 1.5 years.
That's the most unfortunate part.
It is very unfortunate. Yeah, okay, fine. Got my answer. Thank you, sir.
And you see, the only safeguard is that if the company goes to the liquidation, then your fees is priority number 1, as per section 53, subsection 1, clause A.
But sir, in this case, IRP can also, I mean, let's say, if this is not being decided, IRP has an option of applying to AA and ask him to get released, right? That is an option available to IRP.
You can request, but the chances are remote.
Okay.
The only thing here in what you mentioned, there's one catch. Like the COC has not approved the fees.
They have in fact rejected fees.
They have rejected the fees. So then
Yes.
it becomes a subject matter of IA by the IP,
Yeah.
saying that the adjudicating authority should decide the fees.
Yes.
Once the adjudicating authority decides the fees, then only it becomes a priority payment under section 53.
Okay.
Because the situation is like that. In case of the first COC, they will decide whether to approve or ratify the expenses incurred by the IRP. If they approve, it is payable. If they don't approve, then it is not payable by the corporate debtor. It is payable by the applicant. And whenever this CRP is set aside by NCLAT, NCLAT directs the adjudicating authority to decide the fees. And whatever the adjudicating authority decides, the fee is payable.
Okay.
And there has been a case where the CRP was set aside. The matter was remitted back to the adjudicating authority for deciding the fees. Adjudicating authority decided the fees in terms of the guidelines of the professional institute. And then it was challenged before NCLAT. NCLAT also upheld the quantification of the fee. Then the matter was before Honorable Supreme Court. So the Supreme Court also upheld the quantification. The only change the Supreme Court made was that since the fee and expenses of the IRP becomes the CRP cost if the COC approves. And in that case, COC has not approved. So the only change in the direction was that let the applicant pay it. So whoever was the applicant for the CRP was made responsible for making payment of the fee, which was quantified by the adjudicating authority and upheld by both NCLAT and Supreme Court. The CD was not responsible to pay. So that's the only difference. But the fee has to be paid because he has carried out his statutory functions, and it's the obligation of adjudicating authority to quantify and fix his fees.
Sir, in a case where the NCLAT has not given such a direction regarding the fee of the RP, and he has stayed there for almost 2 years, and after 2 years, the matter was set aside by Honorable NCLAT. In that case, whether still an IA can be filed by the IRP to...
Yeah, but I don't understand. Invariably, when the NCLAT is setting aside any CRP order, they include that line, unless the COC has fixed, let the adjudicating authority fix the fees.
In my case, the COC was not constituted. There was a stay on the COC, and the NCLAT, while setting aside the matter, it continued for more than 2 years, and the NCLAT did not specify any line in this regard in the entire order regarding the fee of the IRP. And all the meetings were attended, all the courts were, applications were filed with various courts, even High Court, Supreme Court, and all the fees still in doldrums.
Is it not yet finalized?
The order has been set aside, and the fee
No,
will
no.
have been given to
About
the
the
applicant.
fee.
The fee has not been finalized by.
Yeah. Have you filed your IA?
No, I have not filed the IA. I have still given the bill to the applicant. If he doesn't pay, then probably I'll file the.
Yeah, better, because there has been a similar case that was Alok Kosik versus Bhuvaneshwari. That was the valuer. So what has happened? This CRP was set aside, and the valuer's fee was not paid. The RP said that there is no provision, the COC is not approved. So when this RP approached the adjudicating authority said we are functus officio. Once it has been set aside, we don't have any power to fix the fees. And the appeal in NCLET was also rejected. But fortunately, Supreme Court took a very positive stand, saying that the professional was appointed by the RP, who is appointed by the court or the adjudicating authority. And he has done his duty. He has raised the bill. He has given the report. So it is the responsibility, or it comes within the domain of power of NCLT to fix the fees. By virtue of section 60, subsection 5, that residual clause C, any matter related to the insolvency, it is the domain or jurisdiction of the adjudicating authority to fix the fees. Another case, Devarajan's, that was also on the fee. And again, Supreme Court relied it on its own decision in Alok Kosik's case and remitted it back to the adjudicating authority to decide it on merits. So the only answer in your case is an application to the adjudicating authority to fix your fees for the period you have worked as a IRP or RP.
Thank you, sir.
And you can quote those case
Judgments.
laws.
Yes, yes. Alok Kothari's case and Devarajan's case.
Alok Kosik.
Alok Kaushik's case, yes.
And Devarajan.
Sir, one more question regarding CRB 3.
Yes.
Sir, when the IM is not prepared because of non-availability of information due to non-cooperation and 19.2 is still pending, whether we are still supposed to issue it with whatever information we have in our possession by the 95th day, or we wait till the information is received? What is the...
See, then it becomes endless.
Yes, sir.
Whatever information you have to prepare the IM with the writer. You can make a disclaimer in that.
Okay.
Whatever, and there is a provision that you can always amend the IM whenever you have additional information.
Yes. So better to give it within time.
Yeah, that's one has to be very careful. Whatever may be the constraints, you have to keep on going ahead with the timelines and the activities which you are to perform.
Thank you, sir.
Okay. So can we go ahead? So these are the 5 forms. Later on, they came out with a CRP form 6, which is event specific. In case of certain events, this CRP 6 has to be filed. That is again within 7 days of the occurrence of the event. CRP 7 was added for reporting delays. So whenever there is a delay, within 3 days of that, you have to file the form CRP 7, and again specific situations are given where you have to file the CRP 7. CRP 8 is for the preferential and other transactions. Earlier, there was a provision that when you are determining that the corporate debtor has been subjected to PFA transactions, you were submitting a report to IBBI. So that provision has been changed. Now this form is to be filed on or before 140th day of insolvency commencement date. Now, Form 6 is to be filed in these situations. Unfortunately, this has not been amended. Now there is a specific form for PFU transactions, but it is still mentioned here. That's the first item, because earlier Form 8 was not there. So event specific, when you were filing an application for PFU, this form has to be filed. Second was raising of interim finance. And when insolvency resolution process, the guarantor starts, extension of the CRP period and exclusion of time, premature closure of the CRP, appeal or settlement or withdrawal, then request for liquidation before the completion of CRP, non-implementation of the resolution plan as approved by the adjudicating authority. So in these situations, Form 6 is required to be filed, that is within 3 days of the happening of the event. Form 7 is filed for delays. And these are described like delay in public announcement, delay in appointment of RP, when the IOM is not issued, or when the RFRP is not issued, or when the CRP is not completed. So that is Form CRP 7. Now, one strange thing about the CRP form is that you can file only one CRP 7 form in a month. So if there is a delay in one or more activities, then you have to file only one form. And that has caused a lot of difficulties to the IPs when there are overlapping situations and leads to default. Here are some examples given. Like if the public announcement is not made on T plus third day, then CRP 7 will be filed by T plus 6 days. That is within 3 days of the last date for the event. And thereafter, if the public announcement is made on T plus 16th day, no further form CRP will be required. But if the public announcement is not made till T plus 33rd day, then CRP forms 7 will be filed on T plus 36 days. So there has to be a gap of 30 days in filing Form CRP 7. Now a situation where there are two defaults. RP is also not appointed on T plus 30th day. So through though the CRP 7 forms becomes due on 33rd day, but you can only file it on 36th day, because you have already filed one form and the gap between two forms should be 30 days. So this at times creates inconvenience or problem for the insolvency professionals. So this part is clear, Form 7.
Yes.
Okay, you want a break of 5-10 minutes or we continue?
Can continue, sir.
Okay. In case of CRP 8, there is another condition imposed that it has to be filed on or before 140th day, but not earlier than 30th day from the ICD. This is regarding the late fee. If there is a delay of even 1 day, then the penalty is rupees 500. And the delay up to 1 month, each calendar month delay is 500. When you cross the calendar month, then it becomes 1000. This is the chart, how the delay will be calculated. These are the consequences of late filing the form, apart from the financial penalty. Can somebody read this part, this slide?
Yes, sir.
Please go ahead.
Yeah.
Sorry, can I read?
Del-
Or Manish?
Yes,
Manish,
yes.
आप पढ़ रहे हो?
yeah, I can also read if you want. You can, sir.
No, go ahead. No problem.
Okay. Delay in filing forms. IP or IRP or the RP shall be liable to any action which the board may take as deemed fit under the code or any regulation made thereunder, including refusal to issue or renew authorization for assignment. 4. Failure to file a form along with the requisite information and records. Inaccurate or incomplete information or the records filed in or along with the form. Delay in filing the form. And the next is Regulation 40B, subsection 4, with effect from 25/03/2020.
So apart from the additional penalty which you have to pay, this will also create a problem in terms of issuing the authorization for assignment. And without that, you can't practice as insolvency professional. So one has to be very, very careful in filing these forms in time. One thing I forgot to mention you about this form IP1, you need to be very careful. Particularly in case of voluntary liquidation, there is a provision in that which says the resolution by the corporate person when it was filed. So when you give your consent as an insolvency professional, there is no resolution because the resolution can only be passed after you give your consent. And there is a minimum time of giving notice for holding the meeting. So what happens is the resolution details are never available when you give your consent. So don't try to modify it later on when the resolution comes in. I had a bad experience about it. So earlier, they were permitting the modification. Later on, they charge the penalty. They will consider what was the date of your consent. I had complained, but they said it is system driven. But unfortunately, whatever is system driven can always be changed when there is a problem. So, but that is not there. So you be careful. Once you have filed the IP1 form, don't try to modify it for any additional details. Else, the penalty will be imposed on you. And never try to experiment with amending these forms. One of my friend was trying to see what happens. He opened that form, and after a year, he was charged huge penalty because it has calculated every month delay for the modification. So once the form is filed, forget about it. Don't try to modify it. And with every form, there are a lot of enclosures prescribed. So that has to go with the form. And it is now on the IBBI portal. These are the time-based reports apart from these forms. Monthly status report every 7th day of the month, and half-yearly reports April to September, October to March. So 15th October and 15th April. Then earlier, the list of creditors was to be filed or kept in the office and filed with the adjudicating authority. Now this is also to be uploaded on the website of IBBI. There is a specific portal where you have to keep on updating the details of claims received and admitted by you.
Sir, any precaution before giving IP1 in the matter of section 10 of IBC?
See, the moment you sign your form 2, whatever date you put on that form, within 3 days of that, you will have to file your IP1. It may so happen that you don't have all the details at that point of time, but whatever details you have available with, you should submit it and never try to modify it. Any specific query with reference to section 10?
So there you have to give status of the company regarding their inability to pay the amount regarding section 10.
So you check whether it's a compulsory field, like without that you can't save it.
No, it's not compulsory.
Yeah, so wherever it is not compulsory, then you can update it without that. Otherwise, since it is section 10 application where the promoters are willing to share the information with you, you can ask for those information and update it, provided you keep the timelines.
Okay, thank you.
Sir, I have one query, not regarding this form, but regarding the because I think it's a 4-5 months back one circular come regarding the number of assignment that IP can take at a time.
Okay.
So whether it include the PG to CD cases also, sir?
What is your option, your opinion about it?
Yeah, it should be included.
PG to CD is not included.
Achha. Okay.
See, the language of that clarificatory clause is that whether you had acted as IRP or RP.
Yes.
And it includes the PPIRP, but it doesn't include liquidator.
Okay.
So
Sir, I have one query.
Haan, boliye.
So regarding monthly status report, I mean, where we have to, whether we have to update it through email by
There are
7th of
different,
every month.
there are different processes of these 3 IPAs. In case of CMA, this is through email. And triple IPI has a Google form that has to be updated. So that is you are the member of which IPA?
ICSI.
ICSI.
Triple I.
What is the process there?
Actually, we are not submitting whatever. I mean, now see, if some stay or something is there, we are reporting it through email only. But other than that monthly status report, we are not filing it, sir.
Why you are not filing it? You don't get any reminder?
No, sir.
But since when you are not been filing? Because at the time of issuing AFA, may I request others to mute the mic, please? When you are applying for AFA, they will look into it whether you have filed the monthly reports or not. And
yes, sir. Just now, I mean, last week only I I renewed my AFA, but they have not asked for the same.
So you are lucky.
That is applicable, I think, if you have
For
assignment,
ICAI, I guess.
ongoing assignments. Yes, yes.
No, ongoing assignments are there. That's why I am asking.
I think it should have been. I don't know. Because otherwise, the other institutes will give you a reminder. Some
I to inform that there are no monthly reporting compliances in ICSI IIP.
No monthly requirement. Okay, that's great.
Sir, and in triple IPI, they have done away with Google Form now. They have created a utility where you need to go and, I mean, it is more simpler than the Google Form, because in Google Form, you had to update everything every time. Now, a lot of information is saved and you have to record only the change or a new assignment in that, what they call is master utility.
So you see the 3 IPAs following 3 distinct requirements or process of filing monthly report. Good to see, Rajesh ji. Okay. So any other comment or observation on this part? I am updated about the monthly report status of all the 3 institutes now. That's the advantage of sharing knowledge. So another requirement, that copy of application for initiating this personal insolvency is also to be filed with IBBI. Copy of application for insolvency resolution process of the personal guarantors to be updated. List of the stakeholders is also to be updated with IBBI in the case of liquidation process. It has not been done for voluntary liquidation case. But in case of voluntary liquidation, you don't need to upload it on the portal, but you will have to submit it along with the list of stakeholders whenever you are sending your preliminary report. These are some more compliances which you are aware of. And the most important is that after the resolution plan is approved, then you are to forward all the records relating to the conduct of the CIRP process and the resolution process to the board as well as to the insolvency professional agency. So here it is only the digital record. You have to scan and send it on either a CD or a pen drive. Otherwise, you are responsible to maintain the records. And what are the timelines for the records to be maintained by the RP?
7 years.
Yes, Ms. Subham Agarwal.
7 years.
7.
Subham, what is the timeline for maintaining records? Are you able to listen? Subham Agarwal. See, the earlier requirement was 3 years as per the regulations. That was probably the code of conduct. Later on, they have added this regulation, the CRP regulations, which says 3 years physical and electronic record, 8 years. And what is the timeline from which you will conclude that 3 years or 8 years? Just confirm it is 7 years or 8 years.
7 years.
7 years. It is mentioned in regulation 39A. Okay.
Yes, yes.
The
yes.
timeline is from the date all the litigations are over. Like,
but we'll confirm. We'll confirm.
Yeah. Say, like if the resolution plan was approved on 1st January 2023, and there is an appeal pending before NCLAT, and then there is an appeal before Supreme Court. So when all the litigations are over, the timeline of 3 years and 7 or 8 years will be from that period. So it could be a very long period for which you have to maintain if your matter is litigation. Public announcement on the website of the IBBI. Earlier it was to be sent through email. Now it can be uploaded. And then disclosure of the cost. As we have seen, the June 2018 circular notified that 3 forms are to be filed by the IRP and RP. Now it is part of the regulation where you have to disclose the cost, and the costs are to be disclosed on the portal of the IPA concerned. And this is for the public at large available. Anybody can see what the costs you have incurred in the CRP process. There was a discussion in the BLRC report, and that was the purpose. The level of the fee was not fixed, and they said that let it be known to the public at large the performance of the IP and the cost incurred. So it should be a market-driven approach where the informed stakeholders decide as to whose services to be taken. That was to maintain transparency. And that's how this regulation has been added. And these are available on the portal of the IPS. You can check the cost of any assignment. Under the pre-pack also, there is a requirement of filing reports and other documents. It is prescribed under section 54A1. And the regulations also provide that whatever reports are to be specified by the regulator, these have to be filed. So there's a requirement under every process of filing the reports. Under the liquidation process, you have to file public announcement, like in case of CRP, list of stakeholders. Then you have reporting like a preliminary report, asset memorandum, progress reports, and the final report prior to dissolution. Preliminary report is to be filed within 75 days of the liquidation commencement date. Progress reports every quarter within 15 days of the end of the quarter. And whenever the assignment ends or there is a change in the liquidator, then within 15 days of the end of that quarter. Within 15 days of the date when the liquidator ceases to be the liquidator, or within the completion of the liquidation process. This is an example how the quarter-wise reports are to be given. So the calendar quarter requirement is maintained. Whenever is your appointment, if it is in between the calendar quarter, then also the first report will be at the end of that quarter itself, even if it is not complete period of 3 months. And similarly, the last quarter, when the liquidation is over, you will have to do it within 15 days of your completion of liquidation process. Asset memorandum is to be submitted within 30 days. Similarly, asset sale report, and this will be enclosed with the progress reports. So depending on when the progress report is to be submitted, this sale report will also be submitted. Under voluntary liquidation, sorry, this is not this is liquidation process. The regulation 34 is liquidation process. This is for the voluntary liquidation. Appointment has to be informed within 7 days. So here, this is not through the forms. IP1 is to be filed when you give your consent to take up the assignment of voluntary liquidation. But when you actually get that assignment or the resolution, special resolution of the general body, then within 7 days, you have to inform it to the board as well as the registrar. So you inform to the board through email and to the registrar through filing of Form GNL2. Again, public announcement is to be uploaded on the website of the IBBI. The list of stakeholders to be displayed on the designated website of the board. And they have changed the timelines, like it was 45 days earlier. Now it is 15 days from the last date of receipt if there are no claims. If there are claims, then it is 45 days. Because in case of voluntary liquidation, they have curtailed the period. Earlier it was 1 year to 70 days. Now they have reduced it to 90 days where there are no creditors. And these proceeds of unclaimed deposits are to be given prior to submission of the application for voluntary liquidation. Preliminary report within 45 days, annual status report within 15 days from the end of 12 months, and after that, every year, final report within 270 days of the liquidation commencement date, where there are creditors, and if there are no creditors, then within 90 days from the liquidation commencement. In case of individual insolvency, the discharge order is to be filed with the board under section 92. And if the repayment plan is rejected, then that order of adjudicating authority rejecting the repayment plan is also to be submitted to the board. So there are three situations where the bankruptcy can be initiated if the individual insolvency resolution process fails. It is not like automatic process as it is in the case of CRP. If the resolution plan is not approved, then the liquidation will be compulsory outcome. But in case of individual insolvency, it is not so. And these are the three situations where the bankruptcy process can be initiated. The first one is when the repayment plan is rejected. So here also you have to intimate the board. The second situation is that when the repayment plan comes to an end prematurely, means that the repayment plan has not been fully implemented. So in that case also, the order passed by the adjudicating authority has to be submitted to the board. Discharge order under insolvency resolution process under section 119, that is also to be submitted to the board. Here it is not very clear. The name of RP is not mentioned. And some cases it is written as adjudicating authority, but the liability comes on the RP. The RP has to keep updating and sharing the orders with the board. Like the discharge order in case of individual insolvency, the discharge order in case of bankruptcy is also to be submitted to the board. Now, these are the details of different forms. We have seen in summary what are the forms to be filed. Like what are the details to be filed in case of IP1. So now I'll request the participants to read these slides one by one. Otherwise, it will become very monotonous. So I have IP1 pre-assignment form is to be filed by the IRP, RP, or the liquidator at the time of his appointment and thereafter in accordance with the code of conduct. The timeline is within 3 days of signing of Form 2 or Form AA or any other form which is filed in case of acceptance of any assignment. So pre-assignment includes the consent to accept the assignment as IRP, RP, liquidator, and a voluntary liquidator also. The details to be filed in this are the name of the IP, the applicant, like who has initiated the process, the person which will go undergo the process. So these are the details of the corporate debtor or the corporate person. Terms of consent and engagement. The attachment is in the form of copy of the written consent given. So these are the requirements of Form IP1. We have already discussed the period is, this is the CRP1 form. Period is from commencement of the CRP till issue of public announcement, and timeline within 7 days of making the public announcement. These are details to be filed in the CD, like the name of the IRP, the corporate debtor, and the applicant. Admission of the application by AA, public announcement, suggested authorized representative, non-compliance with the provisions of the code, regulations, circulars, and other laws applicable to the CD. Whether any application has been filed under Section 12A for withdrawal. So here, as far as the IPs are concerned, we are in a very strange situation that we have to admit our own non-compliances. Every form you say, there is a specific statement to be made by the insolvency professional indicating where there has been non-compliance or which provisions have not been maintained. This is sort of unfair that you are admitting your mistakes and then you make your subject matter of penalty. That yes, you are liable to be imposed penalties on this. Expenses to be incurred on or by the IRP fixed by the applicant or the adjudicating authority. Existing proceedings under the Companies Act, the SICA Act against the corporate debtor, if any. These are the attachments with which the form CRP1 should be supported. Mr. Nitin is there? Sarthak? The requirements in terms of the file, in terms of the forms are so boring. Anybody would like to read this slide?
Yes, sir, I will read it.
Yeah.
What do you want, sir? Form CRP1 attachment.
Yes, yes. These are very monotonous details. Nobody would like to. Yeah,
you are
can
not
go
audible,
ahead.
Sir.
I'm not audible.
Application filed with the.
Yeah,
it's okay now. It's okay,
yeah.
sir. Application filed with the AA. A order admitting the application. AA order appointing the IRP. Form A, public announcements. Form AB, written consent to act as AR. Cost and relationship disclosure made to IPA. Form FA, application for withdrawal of CRP, if any. Orders of the court, tribunal, if any. Other documents, if any.
See, when you see the list of attachments, it indicates the bureaucratic mindset. When you are asking details, you ask for anything and everything, whether you will be able to read it or not. And just see, we have discussed about the duplication. The cost and relationship disclosure made to IPA. which you already done on the portal of IPA, again put it here. And there are several instances where they have found discrepancy in the disclosure done on the IPA website and what was attached with the CRP form. So the moment you have obligation to put the information at two places, these type of errors are bound to occur. So there's a need to streamline that things already uploaded on the one regulator's website should be automatically linked or taken care of instead of asking to give it again. CRP Form 2, the period covered is from public announcement till confirmation or replacement of the IRP. The timeline is again 7 days from the date of replacement. And if there is no replacement, then from the assumed date of the time when the IRP will start functioning as the RP. Details to be submitted in case of CRP2 form. AR selected by the IRP or a class of creditors. Details about the management and custody of the corporate debtor. Claims of the creditors. Constitution of the COC. First meeting of the COC. Confirmation or replacement of the IRP. Applications seeking cooperation of the management, if any. Application filed seeking assistance of the local district administration under Regulation 30, if any. Expenses incurred on or by the IRP. So again, this is sort of duplication. The cost and the expenses incurred by the IRP are also to be uploaded on the website of the IPA, and it is available for public to see. And again, this is part of the Form CRP2. Disclosure of relationship of the IRP and professionals. Support services, if any, taken from the insolvency professional entities. Support sought from any professionals. Resolution under section 12A or 33(2), if any, passed by the COC. Details of deviations and non-compliances. Again, you will be giving evidence of all your deviations and non-compliances which you can't refute. Attachments of the CRP2 form will be list of creditors along with the details of the claims submitted with the AA, report certifying constitution of the committee of creditors, latest audited financial statements of the CD, minutes of all COC meetings till the time frame for which the CRP2 form is to be filled. A's order admitting application for CRP, progress reports filed with the adjudicating authority by the IRP, cost sheet prepared by the IRP, cost and relationship disclosures made to the IPA. Again, duplication here. The documents attachments. A is order under section 19(2) application. A is order for assistance by the local administration. A adjudicating authority orders for replacement of IRP by RP. All applications filed before AA. All applications filed before any other authority. All orders passed by the AA. All orders passed by the courts. Any other relevant documents. So long list of attachments to be made along with Form CRP2. Form CRP3, period covered, appointment of RP till the issue of information memorandum within 7 days of the issue of information memorandum. Details to be provided. Can I request Sureshji to read it? The details to be submitted in CRP Form 3. Please unmute yourself.
Yeah. Form CRP 3, details to be submitted. Registered valuers, handing over of records of CD by IRP to RP, custody of assets of CD, date of submission of information memorandum within 2 weeks of RP appointment, but not later than 54th day. Application seeking cooperation of management. Application seeking assistance of local district administrator, and then information memorandum.
These are if filed, applications if filed. Okay, you can continue with this.
Non-compliance with the provisions of the code and other laws. Whether undertaking of confidentiality obtained from member of COC and resolution applicants.
So at every form stage, whatever has been the non-compliance of the provisions of the code or any other law, you have to specifically mention it. And all the applications filed during that period, all the orders of the adjudicating authority or any other court where there is any litigation going on. So it is just like a comprehensive detail being asked for by the IBBI. I don't know whether IBBI has sufficient staff and manpower to go through all these details submitted. Even the RPs find it difficult how the regulator will be able to see, but this is the way.
So I have a question here. When it says to all the members of the COC, is it to all the participants of the COC or only to the members who are the...
Can you repeat the question? First part I couldn't listen.
The IM is to be shared to the members of the COC. It says it has to be only to the members or to the participants also.
Say the IM is to be shared with the
members of the COC.
Creditors.
Pardon?
But it is not required to be placed before the COC. Otherwise, what will happen? Any decision is to be taken by the COC. You have to give details as notice in the agenda items. So there is a decision of Honorable Supreme Court with respect to sharing of the resolution plan with the participants, particularly the promoters and the directors who are entitled to attend the meeting. So that Supreme Court has held that since you have to give a notice to the participant, and notice includes the agenda and all the documents to be placed before the COC. So the resolution plan you have to share with the directors.
So I'm only asking about information memorandum, sir. Whether
No,
it is
information memorandum is not to be placed before the COC.
No, to be shared with the COC. The previous slide was it has to be shared. You have to report that it has been shared with the COC.
Shared with the members of the COC.
With the members of the COC. So members only the financial creditors who are the members or the other participants also.
So it can be shared through email after obtaining the confidentiality.
Even to the earlier directors also?
No, this is only to the members of the COC.
To the members of the COC.
Directors are not COC members.
COC members. They are only participants for the purpose of...
So there, if you put anything for approval of the COC or for the information of the COC, then it will be obligatory to share it with the participants. But here the provision is clear that you have to take
only to the members.
Confidentiality undertaking and then share with the members of the COC. It is through electronic mode.
Even with the operational creditors who are participants?
No. This is not for the participants. This is for the members of the COC.
Okay.
The
Only
OCs are not members. They get
yes.
right only to be observer if
Yes.
the debt is 10% or more of the total debt admitted.
Yes, sir. Yes. Thank you, sir.
Anybody else would like to share the experience regarding the memorandum, information memorandum? Have they come across a situation where the directors have asked for IM? Yes,
There is
somebody.
a recent judgment of NCLAT that
Okay.
the creditor who is a participant in the meeting of the COC has no right to seek a copy of the information memorandum. That is very recent judgment, maybe in the last week.
Can you share that with me?
Yes, sure. We'll share.
Okay. There was a case by the promoters to share the video recordings of the meetings. And NCLAT has rejected that. Even they went to the High Court saying that we should be given the recordings of the meetings of the COC. So it was rejected, saying that that's not your right to ask for the information.
Sir, here one thing, whether AR of the home buyers can ask the recording of the COC meeting?
I don't think.
Because he's also COC member, no, sir?
Yeah, the COC member cannot ask for the recordings.
Okay. And one thing, sir, this valuation reports, because under regulation 35(3), it says that no, the RP need to share the valuation report, fair value and liquidation values, not complete report. So without complete report, how one will make it out what is there, no? What is the basis and all the things. So whether it, as a COC member can ask value complete reports?
Yeah, and generally it is being shared with the COC members. Though the regulations talks about the value. But if you see in the overall scheme of the things, since the financial creditors have been privy of all the information, they have been evaluating the project for giving the loans and all those things. My personal opinion is that there's no harm in sharing those reports, though the regulations speak slightly different.
Thank you, sir. Thank you, sir. Because 35(3) regulation under section regulation 35(3), it talks about information memorandum, all the critical information COC can demand. But 36(3) says only fair value and liquidation value.
And as regards the valuation reports, the provision is that, of course, there is one, I think, section 21(9), which talks about the financial information sought by the the COC members has to be provided within 7 days. But as far as the valuation reports, there is a specific provision that it can be shared with the members of the COC only after the last date of receiving the resolution plans. So that is to avoid any unfair advantage to the members of the COC in case any of the members of the COC is interested in submitting a resolution plan. And otherwise also because of the some instances where the information got leaked, this provision was made that it will be shared only when the resolution plans are submitted.
One last question, sir. In case resolution plan is non-compliant under section 32 something, okay, and whether this resolution plan can be put for voting to see the commercial and other aspects of the COC members? Because it's non-compliant. RP is not supposed to put for voting. It's non-compliant. Whether you can put in the minutes, it's non-compliant, it's still for the purpose of commercial and other wisdom, commercial aspect, it is put for voting.
You say
because first of at first instance one cannot put the non-compliant plan for voting, right?
Yes, the even if it is put for voting, and let us assume that the COC approves it, then by virtue of non-compliance to section 30 subsection 2, the adjudicating will have a right to reject this resolution plan. So not worth doing that exercise, and will speak badly on the part of the RP as to why he has submitted that plan for voting.
Yeah, this non-compliant plan is not supposed to put for voting.
Yes, yes. And actually there are two provisions which are confusing. One, and both provisions are in the code. One says that RP has to submit all the resolution plans before to the COC, and one says that it has to put the compliant plan for voting. So the best way of going ahead is that the RP places all the plans before the COC and his due diligence report saying that these are the plans received. These are the plans which are compliant with the provisions of section 30 subsection 2, and these are the plans which are not compliant. So the only compliant plans will be put for voting.
Okay, thank you, sir.
These are the list of attachments for CRP 3. So I need volunteers to read these slides. Should I take name?
Yeah, I can read, sir.
Okay, please go ahead.
Yeah, Form CRP 3 attachment. AA order for appointment of RP, latest audited financial statements, provisional financial statement for the current year, information memorandum, valuation report, appeal application filed before the AA and Enclave High Court, Supreme Court, others, order of the AA Enclave High Court, Supreme Court, others, progress report filed to the adjudicating authority by the RP, cost and relationship disclosure made to IPA, any other attachment.
Okay, thank you. And then CRP form is to cover the period from the information memorandum till RFRP. Timeline is 7 days from the issue of RFRP. Details to be submitted, RFRP and the modification thereof, evaluation metrics and the modification thereof, non-compliances with the provisions of the code and other laws, details of persons ineligible in section 29A and 25(2)H. What is the difference between 29A and 25(2)H? (29A) is the ineligibility criteria. 25(2)H is the eligibility criteria to be fixed by the RP in consultation with the committee of creditors. So these are the two aspects. One is ineligibility, which is prescribed under the code. Another is the eligibility, which is prescribed by the commercial wisdom of the COC. Whether due diligence on PRA conducted by RPs as per regulation 36A, details of any orders passed by the adjudicating authority. Attachments for the CRP4, expression of interest, first and latest. Now there is only one time when it can be amended, or you can ask for the plan. So first and the last. Evaluation metrics, including modified, if any. Minutes of the COC meeting approving the RFRP. All applications filed before the courts and orders passed, if any. Progress reports filed to the AA by the RP. Other documents, if any. Okay, that reminds me of one issue regarding the progress reports. There is no specific provision in the code or the regulations for the progress reports. But as a matter of practice or good practice, periodically the progress report should be submitted to the adjudicating authority. And when it is submitted to the adjudicating authority, also to the COC and also to the IBBI and IPA. Chandigarh NCLT at times is very demanding. In the initial stages, it was asking submission of the report every week or fortnight. Some of the adjudicating authority benches insist for it. Otherwise, it's a normal practice that generally you should submit a report once in a quarter, or if depending on the nature of the business or the corporate data, and depending on the situation, you can submit every time a COC meeting takes place.
This is by way of email or physical?
No. This is by way of an IA, and earlier there was no fees asked by the NCLT. Now even for your reports, they are asking for a fee of rupees 1,000. Any IA filed has to be with the fee. CRP 5 covers the period from the issue of RP till completion of the CRP. Timelines again 7 days from the date of approval or rejection of the resolution plan under section 31. Details to be submitted. Updated.
Sir, one query is there, sir.
Pardon? Yes, please.
One query is there.
मनीष जी, आपकी आवाज कट रही है.
In many cases, sir. अभी आ रही है? Hello.
हाँ, अब ठीक है.
Am I audible, sir?
Yes, better.
अभी आवाज
आ रही है.
Okay. In many cases, sir, COC want that the RN. In many cases, COC want that the advocate or the valuer should be appointed, suggested by the COC. So, how to deal with that situation, sir? Because it's affecting the independence. If we
very difficult situation.
Yes, sir.
Because
very difficult. But how to handle? Because
you see, you should be convinced as to who should be appointed. There are cases of disciplinary action against the insolvency professional when they have appointed the valuer insisted by the members of the COC. So it's a clearly indication that the valuer has to be an independent person. It should not be influenced by one of the members of the COC. Regarding advocates, it's a tricky situation. At times, the COC would like to field a senior advocate, highly paid advocate. So the situation, how you handle is very clear. They said that if the COC is to be represented in any matter, they are free to appoint any advocate, whatsoever is the fees. But if it is part of your decision, then you have to be convinced and you have to record the reasons for your decision that why you appointed a particular person. So these are very tricky situations and you have to handle it very carefully.
Yeah, I am talking for appointment of advocate for RP purpose only, for authorizing the RP before the various authority.
Yes. You have to be convinced that you are appointing it. You should never record it that because the COC listed it, you appointed it. That will be disastrous.
Okay, sir. Can you, sir, share the disciplinary action means, or you can share the name of the case law where actions are taken against the RP, so that we can convince to the COC that we can't do because already earlier these things are already happened.
Okay. You give me your you send me a message. I'll share.
Yes, sir. I will send, sir. Yes, sir. I will send, sir. Thank you, sir.
So these are the details to be submitted with CRP 5, updated list of claims, reconstitution of the COC, resolution applicants, details, resolution plans received, approval or rejection of the resolution plan by the COC, claims as in the date of the meeting of the COC, where resolution plan was approved, application filed with the adjudicating authority for approval of resolution plan, initiation of liquidation if it is applicable. Other details are like expenses incurred by or on RP, appointment of professionals in terms of their appointment, relationship of the RP with the CD, FC, and the professionals, support services taken from the IP entities, non-compliance with the provisions of the code and other laws, details of other orders passed by the courts or tribunals. So most of the things are common to all the forms in terms of whatever the orders or the application filed or the non-compliances, cost details.
Can a
And
COC suggest for liquidation of the company after receiving 2 resolution plans and after crossing the 180 days, after getting the extension, the CRP is in the extension period now. The resolution plans submitted and it is under discussion by the COC, but they're not satisfied with the resolution plan. So can they go for liquidation?
who has the commercial wisdom? COC. And the commercial wisdom includes approval or liquidation. It is within the rights of the COC.
Is this possible during the extended CRP period?
Yes, yes, it is possible. Why not?
Okay.
Because the COC wanted to consider the resolution plans, the extension was requested. They may not find it worth, so they can go for liquidation. Earlier, there was sort of unwritten law that adjudicating authorities used to insist that unless you have done the process of inviting the resolution plans and it has failed, you can't go for liquidation. But then the provision was amended. Even the very first meeting of the COC can decide whether to liquidate it or to whether to go for liquidation or to invite for the resolutions. So there is no restriction as such in terms of the point of time as to when the COC can take a decision for liquidation. Are you satisfied?
Yeah.
Okay. So as a bonus, would you like to read this slide?
Sure.
Yeah, please.
Form CRP 5 attachments, minutes of all COC meetings, copy of a resolution plan, disclosure of cost and the relationship made to IPA, all the applications filed before adjudicating authority, all the orders passed by the adjudicating authority, all the applications filed before courts, if any, all the orders passed by courts, if any, compliance certificate Form H, progress reports filed with adjudicating authority by the RP. Any other attachment related to resolution process, say process document, bid documents, etc. Cost sheets prepared by RP, other documents. What is this cost sheets?
These are the expenses.
CRP cost.
CRP cost.
Okay. Take it. This CRP cost information, does this include the running expense of the CD when the company is in the going concern and the operation is going on, income is coming, expenditure is incurred on a day-to-day basis. So does this cost sheet should include that also?
Yes, there is a difference between the CRP cost to be approved by the COC and the other cost of keeping the corporate debtor as a going concern. In the initial form, way back in 2018, when they decided to introduce Form 1, 2, and 3, it included the cost. So there were columns which made it very clear that the CRP process cost. मनीष जी, मनीष जी आप म्यूट कर लीजिए अपने माइक को. CRP cost, which is for running the processes, which is for appointment of the professionals to carry on the process, is to be approved by the COC. But the other routine expenses of keeping it as a going concern are not to be approved by the COC, but they are to be informed. Like every meeting, you are placing the financial position of the corporate debtor, so it has to be part of it. And this is also part of the cost disclosures. Another thing is that the cost of going concern is also priority number 1 in case of liquidation. That is section 53, subsection 1. So when we say cost sheet, it will include all the costs. When we say the CRP cost approved by the COC, it will be the process related cost, the cost or the fees and expenses of the professionals, which has to be approved by the COC.
Sir, one query is there. Yeah, regarding CRP commencement date. Yeah, suppose AA allow pronounce the order on 1st of December, and the order uploaded on the website after 7 days.
Okay.
And the RP came to know after 10 days, sir, on 10th of December. Example I am giving.
Okay.
So we have to take the date on 1st of December or 10th of December, because RP came to know on the 10th of December only.
See, as far as the insolvency commencement date is concerned, it will be the date of order. That is 1st December. Now coming to the responsibility of the IRP, because there are timelines. So that will be from the date of his coming to know of it. If he was informed of the decision on 10th, then all the timelines relating to public announcement will be calculated from 10th. Otherwise, he'll be in default before coming to know of it. Like if we take 1st December, then the public announcement should have been done by 4th December. By that time, the order was not uploaded on the website, and the IRP was informed on 10th. So it is from the date when it was communicated to the IRP that his obligations will start.
Okay, but if we mention that the CRP commencement date is the 1st of December, then the system will do calculation from the 1st of December only, because there are no any means updated in the website regarding the date of communication. Then how to handle this situation, sir? Because it will calculate all the details from the 1st of December only, sir.
Okay. This is the problem which you have faced in filing which form?
No, any form, sir. Any details we need to file where we there we need to mention the CRP commencement date. So if we mention the 1st December as the CRP commencement date, then all the deadline will be calculated from that date only, sir. Because in my case also I have received the CRP means NCLT order after 5 days. Then I have calculated, I mentioned somewhere that the communication received dated this much and the CRP commencement dated this month. But in the online form fill up, I have done my communication receipt date only, because otherwise I may be default for some of the means due dates.
Okay, that
so my what's the correct situation, sir? Which date we need to mention?
See, that is a very specific issue related to the online portal. Otherwise, legally, when you take the timeline, like the 180 days CRP, that will be counted from the date of insolvency commencement.
That's why I'm telling, sir.
14, yes. These are the issues we'll have to take up with IBBI in terms of the online portal. I told you about the form IP1 also, because it's very clear. If you see, the 14 days from the date of appointment is the time you give in Form 1, inviting claims. And the delayed claims, it makes very clear, Regulation 12(2), 90 days from the insolvency commencement date.
Yes, sir.
Whereas the first deadline is from the date of appointment of the
Yes.
RP. And the date of appointment is when he is communicated. So there could be always a gap between the date of appointment of IRP and the date of insolvency commencement.
So, sir, means in every cases we need to mention the date of communication only, because
as you mentioned that there are penalties imposed for
yes,
delay.
sir. Yes,
In
sir.
that
Because
case, this is the only option. But you will
yeah,
have to
yeah,
take up with the IBBI for.
yeah. We can inform to the IBBI also that we have received this order already. I also inform to the IBBI by email also.
Yes.
Yeah.
Manishi, this is the only practical option. And what
Yes.
I have also done is, I have mentioned the date of pronouncement of an order and receipt of an order in a public announcement itself. So from day one, you have to be consistent doing that. And as Sharmaji said rightly, you cannot start something unless you come to know of it.
Yes.
And while it is not mentioned anywhere specifically, ideally in the law, your timeline starts only when you are served the notice or the order or the
Valid order.
decision. So there's a practical way how
Yes.
you look at it. I think IBBI doesn't. Once you put that IBBI, I haven't come across a situation where IBBI has questioned why you have done this. They are also aware of the practical aspects, and they have, I would say, ignored or condoned.
Okay.
Whatever you want to say.
Okay. Okay. Thank you.
Only
Thank you.
problem comes when the penalty calculation is automated in the forms.
Yes.
Yes.
Yes. Very
Yes.
true, sir.
Yes.
Sir, one small correction regarding 12.2. Now it has been replaced by 12.1 and it says 90 days or before publication of RFRP, whichever is later.
Yeah, this
So
is
in
a
case,
recent amendment where they say that the delayed claims, the RP will decide which are to be accepted and which are to be rejected or not to be admitted. And then it will place before the COC, and then it will also file an application before adjudicating authority for condonation.
so but 12.1 now doesn't say, it says only says that provided further that creditor shall provide reasons for delay in submitting the claim beyond the period of 90 days from the insolvency commencement date. So 12.2 has been replaced by 12.1, inserted from 18th of September 23.
That provision has not been added that RP will file an application. That was in the discussion paper.
No, sir, that is not apparent from 12.1.
Okay. Thank you.
Because there is a say, suppose for in one of my cases there is a stay on form G, then the period is extending beyond 90 days and people are still submitting claims. So initially I had rejected one claim, then I again read the regulation, then found that it can be accepted.
Of course, there have been a Supreme Court judgment, and there was in one case the claim beyond 90 days was not admitted by the RP. It was before NCLET, and NCLET also upheld the decision of IRP, and then matter was before the Honorable Supreme Court. So they have not interfered with the decision of NCLT or NCLAT. So that means they have firmed up that delay beyond 90 days, it is within the role of or the power of RP not to admit it. But again, in many of the cases, the NCLT will say that till resolution plan has not been approved, we keep on accepting.
Yes.
And in some cases, even IBBI has penalized the IP for admitting claims beyond 90 days. So these things keep on happening.
But sir, now since they have clearly made it
now this amended, yes. So these are some of the common errors which have been found by the IBBI and IPAs when all these forms are filed. And these are simple errors of indicating details in the forms, like reasons for delay in filing public announcement was not provided. Earlier, there were no checks. Now they are making more and more checks, making the columns compulsory so that important informations are not missed. Date of filing disclosure with the IPA not provided. The reasons for delay in submission of IM was not provided. Date of filing the application to AA was not provided. Date of filing of list of creditors with AA was not given. Incomplete attachments in the forms. Errors in the date of admission. Amount admitted as debt. Date of confirmation of RP. These are simple, I'll say, typo error or clerical errors. Wrong SIN details of the CD. Timelines not correctly incorporated. Incomplete details of the orders passed by the adjudicating authority or other courts. Details of authorized representative not provided. Mismatch in the information pursuant to the relationship and cost disclosure submitted on IPA website and provided in the CRP forms. That's what we discussed. When there are multiple forms, multiple platforms for reporting, this type of errors are bound to occur. Disclosure pertaining to the IP entity appointed, not made to the IPA. Difference in the date of constitution of the COC given and the actual date of constitution. Date of confirmation is RP not mentioned. Reason for liquidation not provided in the respective form. In case of withdrawal of the CRP, details pertaining to the RP tenure not filled in. This is only facilitating that wherever RPs, the directors are not cooperating, the RPs can use their digital signature for submission of the reports to ROC. So that's it. And on the not very interesting discussion on terms of compliances, it is more of routine things. And we still have some time for discussion and sharing the experience of the participants. So now at least you can put your videos on for the final discussion. It is difficult to carry on for 3 hours for this type of topics. The compliances as such are not very comfortable. The details are not so interesting, but somehow we could carry on.
Sir, can I bring up an interesting issue regarding
Yes.
individual insolvency?
Yes, please.
When the fee has not been approved by the COC and the applicant had appointed under filed the application under section 94, in that case, whether the RP was appointed is entitled to the fee, can he file an IA before the adjudicating authority?
No,
The fee?
see, at the first stage, the RP has made his report.
RP, the process is almost over. There were 2 cases. In one case, the COC approved the fee, didn't pay. The other case, the COC didn't approve the fee. So question of payment was not there. And the regulations are also not clear. They have the powers to approve, but the obligation to pay, unlike regulation 33 in CRP regulations, there are no regulations in individual insolvency where they have an obligation to pay. Neither it specifies about the applicant, as in case of regulation 33, the IRP is to be paid by them, or the COC later when it is the RP. But in case of individual insolvency, no clear-cut regulations regarding the payment of fee.
See, when you read the provisions related to individual insolvency, you will find a lot of inconsistencies and a lot of gaps as compared to the CRP. Since this is almost stay for 6 years in the implementation of this individual insolvency, the things have not been clarified or not modified, as it has happened in case of the CRP. So what we expect is over a period of time, as the
jurisprudence to come in.
goes, there are judicial pronouncements, then things will be better. But I know of a case where, similar to your situation, it has lingered on for long. And fortunately, the fee approved by the adjudicating authority was very good. You would not have imagined that even in the CRP process. So that's the like luck or the special situations of a particular RP. But one thing is clear, that legally, if the adjudicating authority has appointed you as the RP, you have functioned, then you are bound to get the fees.
Because
in that case, you can file an IA with the adjudicating authority, and they are obliged to fix the fee and make directions for payment. Even though there may not be express provisions about it, but it has happened.
Sir, one query is there regarding liquidation.
Okay.
Yeah, in case of the liquidation, if the NCLT appointed the liquidator and thereafter 1 or 1.5 months, the CEO, that stakeholder replace the earlier liquidator. So in that case, sir, the previous liquidator, how he charged the fees? Because there are no any realization. So whether he will charge the fees as per the IBBI guidelines, because stakeholders are not confirming anything, sir.
That's a very tricky situation.
Yes.
Because when the fees is linked to the realizations and
Yes,
disbursement,
yes,
and if there is no realization or disbursement, what fee will you charge?
Yes.
The only recourse is that the situation could be like the COC approves the fees prior to initiation of liquidation. It could be a monthly fee or it could be something else. So that fee is binding. Another option which has been added in the liquidation regulations is that where the COC has not fixed the fees of the liquidator, the stakeholder consultation committee can fix the fees. And if it is not done, then by default that schedule or the percentage based fee will be applicable. So again, as a residual issue, it will depend on what action he has done, he has taken. And the only recourse is filing an application to adjudicating authority to fix the fees.
Okay, that will be the only solution.
That's the only solution. Otherwise,
yes.
How would you fix
got it, sir. Got it, sir. Thank you, sir.
And that Devarajan's case is a landmark judgment, which is for the guidance of the adjudicating authority. What has happened in that case? It was the RP appointed by the financial creditor through invitation of expression of interest. The fee was fixed before he was appointed. But later on, the adjudicating authority summarily reduced the amount of fee. What was claimed was around 9 lakh plus. They said, okay, 5 lakh is sufficient. So then the Supreme Court passed strictures saying that it has to be adjudicated. It has to see the background or the terms of the contract. It can't arbitrarily say that instead of 9 lakh, you take 5 lakh. So it was remitted back to the adjudicating authority, and adjudicating authority based on the agreement between these two, again, finalized and paid the fee. So it has to be a very decision taken based on the facts of a particular case. Rajesh ji, anything to add or share the knowledge?
No, what you said is correct. But sir, I want to ask your another opinion. As a AR of the home buyers, we faced a lot of difficulties. So in one case, there are 200 to 300 claims received. But as per the books of account of CD, there are more than 500 home buyers. So whether in the resolution plan, effect can be given for those who have not filed the claims, but those who are there as the creditors in the books of account?
There is a judgment of NCLAT on this. Particularly regarding home buyers, they have directed that whatever appears in the books of account has to be taken into account. That is only specific to home buyers, not for others. I'm not able to recollect the name. I'll share it with you separately.
Actually, I was also searching that case study, case law.
There is a judgment of NCLAT where they have held that in case of home buyers, you have to take it as per the books.
Right, sir.
And even otherwise, there's a good practice in the information memorandum. You need to mention that though the claims are received so much, and as per the books of accounts, these are the creditors, just for the information of the prospective resolution applicant.
Right, sir. And sir, why we are not asking query? Because you have covered most of the items in your session.
Thank you. But unless you ask the queries, I feel that people are not interested in it.
No. It is not. It is the other way around. Your even slides were also very informative and lot of clarifications you have given during the this, display of the slide. So credit goes to you. You don't think that if queries are less, then people have not understood or they are not taking interest. Not like that.
Thank you for that.
All are doing multiple jobs, sir. Side by side, watching you also and working also. It's a good benefit for all the people.
Sir, I want to bring attention to one of the very peculiar case that I had come across. So what has happened, sir? It was a home buyer matter, and when the application was filed, unfortunately or fortunately, all the financial creditors were paid off by the promoters. So when ultimately the adjudicating authority passed the admission for CIRP, there was no financial creditor, only home buyers were there. So then the IRP was appointed, and then IRP formed the COC, and in the COC, I mean, it was only home buyers, so they appointed AR. So AR actually constituted 100% of the COC. And in the resolutions, I mean, if you see, sir, 66% votes are required. But because it was the COC of all the home buyers, and for AR only 50% voting is required. So then all the resolution got passed by only AR being present, and home buyers, only 50% consented, and then all the resolution were passed. When the resolution plan was actually approved by the COC, the AR resigned. So when the AR resigned, so there is no COC, there is no AR. So there is no grievance of any home buyers being addressed. The resolution plan is still at the stage of the approval of the AA. RP is not admitting any claims of the home buyers anymore. It's a very bad situation. I don't know what to do. And you mentioned that in the IM that all the information and the books of debt, whatever is available, has to be taken. The IRP, when he prepared the IM, so he included claims which were provided to him. And at the same time, he provided a list of all the home buyers on its website, but did not include in the IM. So there were 350 home buyers whose claim was not included. They filed a lot of applications before the NCLT and CLAT. Ultimately, because of some of the other reason, their application got rejected.
Okay. Let me find out that judgment of NCLAT where this is given. Another unfortunate thing is that the way voting is to be counted, it was made very clear in case Sasidhar case by Honorable Supreme Court that it has to be the required percentage of the total 100. Like if the resolution is to be approved by 66% voting, then it has to be absolute 66%, not of present and voting. But unfortunately, because things were not happening in case of real estate allottees, that provision was amended, and this provision of approval is 50% of the voting. Present and voting time. So actually the approval may be even by the 10% of the voting power. in case of home buyers. Very difficult situation. But once when the AR represents the financial creditors and once the COC has approved that resolution plan, which is before the adjudicating authority, I don't think the presence or absence of AR will have any material impact on that.
Sir,
Because
4 years have passed. 4 years have passed still, and then nothing has happened. And the RP is only saying that I can't do anything, and nothing is being because there is no COC, because there is no AR. So nothing is being presented to the wisdom of COC either to cancel the current resolution plan or invite new, because there is no COC at all.
see, there is no probability or possibility of cancelling a resolution plan once it is submitted to the adjudicating authority. Again, there is a judgment of Honorable Supreme Court in EPIC Singapore. Post-COVID, there were a lot of applications. The RAs cried foul that they said economic situation has changed and now it is not sustainable or viable. So allow us to modify it or withdraw. And the Supreme Court has made a very categoric statement that the resolution plan, once approved by the COC and placed before the adjudicating authority, cannot be amended either by the COC or by the resolution applicant. Otherwise, the whole scheme of IBC will got into doldrums. And it's a special type of contract under the statutory conditions, because the normal contract can be varied. And this contract cannot be varied.
I absolutely agree, sir. But the facts of the case were such that out of 1,000
Mr.
home buyers,
Tejas,
350 were
if I may
excluded.
ask you, Mr. Tejas, if I may ask you, why not these home buyers elect another AR and by voting?
Sir,
Has
the
it been
problem is that
attempted?
yes, we have actually filed applications with NCLT as well, but unfortunately nothing is happening. So the delays that are there. So there is no unity, there is no association as such, and that is the advantage that RP and the successful resolution applicant is taking.
Enjoying.
Absolutely.
Earlier, there was a
Unique case.
understanding that COC meetings can't take place after approval of the COC of the resolution plan. I think that is now also very clear that if required, even after approval of this resolution plan, COC meeting can take place. Rajeshji, am I correct?
Yeah, you are correct, sir.
So,
Tapan, Tejas, you can share me the details separately.
Sure, sir. I'll do that.
Let me look into it.
I'll do that, sir. I'll do that. I'm stuck in a very bad situation personally, as well as a lot of clients, but we are
Very
not able to resolve this.
unfortunate situation about the home buyers. I know many cases where the things are dragging on for years together.
Yes, sir.
Even after the
Yes, sir.
resolution plan has been approved, it approved by the COC, it is not being approved by the.
And sir, the SRA is negotiating, terms with specific creditors on one-to-one basis. Be it authority, be it other home buyers, and certain class is being neglected and certain class is being prioritized. And this is obviously off the records, so nothing can be done and nothing can be brought on record as well.
The only rescue is the adjudicating authority, and then the NCLAT, and then the Supreme Court.
Yes, sir. Yes.
Sir, one question. In case of home buyers, sir, one RA is there. Okay, the resolution plan is put for voting, and plan is also non-compliant as per IBC. Though it is non-compliant, still not to check the commercial aspect, they put for voting. Right. So in case of home buyers, what is the option left? Because it goes into liquidation, because one RA is there. For commercial things are also there. Some haircut is also there. So can they oppose the liquidations, and then they can get the direction from the NCLT to get the resolution? Because
as far as the role of RP is concerned, RP is bound by Section 30, subsection 2.
Yeah.
And I don't suggest that if either through negotiation you can make it compliant by asking to make changes, But otherwise, it will not speak good on the part of RP that he is presenting a plan which is not compliant to section 30 subsection 2, putting it for voting, because again the adjudicating authority will not be able to approve it. It's the clear mandate that if it is not complying with section 30 subsection 2, what is the purpose of that exercise?
Yeah, because in case of real estate project, because see, there is a huge haircut to the FCs, and home buyers are getting the houses, RA is there. So in that scenario, whether home buyer can oppose the liquidations and get the things now, because these are also very big questions. Because whether NCLT will allow that opposition to liquidations and all that, because there is no RA in place. Because if the company goes into liquidation, then again, what will the fate of the 3 years, 4 years, 5 years, what is, no, there's also big questions. So haircut is there, no, whether the NCLT will allow to get something, no, directions to the home buyers to
See,
oppose the
that,
liquidations and all that.
that we will not be able to discuss and decide anything here, because you know how the things are decided. Like yesterday only, there is a decision of High Court saying that IP is not a public servant. And earlier, Jharkhand High Court decided that IP is a public servant.
Yes.
So we will have to abide by the judicial authority at whatever level it is. It's the question of interpretation, how they do it. But as far as the
Yes,
role of
commercial.
RP, it is very clear. If it is not compliant with section 30 subsection 2, the efforts should be made by negotiating with the RA to make it compliant. Otherwise, RP will be in trouble. They can question RP anytime that why did you get it approved and why are you placing it before us?
Yes, sir. Thank you, sir. Thank you.
So can we close the discussion now if we don't have
Yes, sir.
any?
Good time. We will have good tea, no? Try the time, obviously.
Sir,
Anji.
yeah, sir, because in the recent judgment, I think you have already seen that the RP is not a public servant in one of the cases, sir.
Yes, yes.
So because as per that, so what's your view, sir?
I told you, no, our view is of no importance.
No importance, but in one cases, in one stand, we are the public servant, but in other places and the other.
Till the Supreme Court decides it, that stage of uncertainty will remain. But the only one thing which I see with this judgment of Delhi High Court is that by virtue of section 238, it prevails over other laws. But then again, in case of criminal prosecution, this overriding effect will not be there.
Okay. Okay.
So let the Supreme Court.
Yes, sir. Decide. Yes. Yes. Thank you, sir.
Here they are trying to argue that the word public servant is missing for IP. That means it is a deliberate legislative intent, and the court should not try to get into the legislative part or putting things which were not desirable.
Yes. Yes. Yes.
Okay, nice discussion.
Yes,
Updations from your side as well, and thanks to all of you. Fortunately, we have completed 3 hours without a break, and I thought it was difficult to continue for 3 years on such a subject.
Thank you very much, sir.
Thank you, sir.
Thank you, sir. Thank you very much.
Nice session.
Thank you, sir.
Nice interaction.
Sir, I request you to please share the PPTs for the session.
Yeah,
Yes.
please circulate the PPT.
Yeah, I'll share that PPT.
Thank you.